Hi there, it's Billy Tarasio from the Modern Divorce Podcast, and today I am joined by another attorney friend of mine. Yes, it seems I have a lot of them, but they're fabulous people, and this is criminal law attorney Shawn Hamp. Shawn, how you doing today?
Hi, Billy. I'm doing very good. How are you?
Good, good. Now you and I know each other from our national connections, and you've got a presence in multiple states, right?
No, actually, my practice is in northern Arizona, but I commute back and forth. I split my time between Arizona and the East Coast.
Got it, got it. So you live on the East Coast, but your practice is entirely in Arizona.
Correct.
That's pretty cool. How did you end up doing that?
Uh, well, with it was a family decision, and but my firm is pretty large and has a good presence all over northern Arizona and Kingman, Flagstaff, and Prescott primarily. And I'll tell you what, with COVID, it does make things a lot easier these days to work remotely and work with the courts. But we have we have we have multiple offices. We have a large attorney firm, lots of support staff. So we definitely help a lot of clients.
Well, that is awesome and wonderful. And I know that I've sent a lot of clients your way. And I wanted to have you on today to talk about the legalization of marijuana and then also the impact of drugs and alcohol and what that can do to your family court cases. But as you know, and as many of our listeners know, in November, Arizona passed a law legalizing marijuana. Now, what does that mean from your perspective as a criminal law attorney?
Right. So, yeah, basically this past November, Prop 207 was passed in Arizona. That's the Smart and Safe Arizona Act. And it was the election results were finalized and codified. And as soon as those election results were verified, the law became inactive immediately, active immediately.
Okay.
And essentially, what Prop 207 does is it decriminalizes marijuana to allow it for personal use. So previously, several years ago, Arizona enacted medical marijuana. Now, with the Smart and Safe Arizona Act, personal possession of marijuana is legal for anyone over 21 years of age, and anyone can possess an ounce of marijuana or less legally without any repercussions. And they can also possess up to 6 plants per person to grow marijuana in their home,
Mhm.
and no more than 12 plant per, more than less than 6 plants per person, up to 12 plants per household.
Okay.
So yeah, it's a big change, and Arizona's following many other states that have also legalized marijuana this past election cycle.
Yeah, absolutely. So I want to clarify something. Now, I know that there are not dispensaries here in Arizona until March, but right now, if somebody has marijuana that they got, wherever, either they were growing it or they got it in California or Las Vegas or Oregon, it's legal. Is that true?
Right. So right now, currently, there are dispensaries that dispense medical marijuana,
Hmm.
and it is still illegal to sell marijuana to another individual, um, unless you're a licensed dispensary. And the process to get a dispensary license has to go through the Arizona Department of Health Services. And they're anticipating that they will allow dispensaries to start legally selling marijuana for personal use in March and April of this year. So it's like a 60-90 day timeline to get that process started. And it's anticipated that the first dispensaries to sell legal marijuana for personal use will be the existing medical marijuana dispensaries, because they have the infrastructure, the legal know-how to get certified, um, So they're anticipated to be the first major players in selling marijuana. So essentially, right now is you cannot legally buy marijuana to possess.
Hmm.
You essentially need to have a friend that's going to give it to you.
Hmm.
Um, in
And
case you're wondering,
that's legal.
right? That's legal. And I believe you could start growing it too, but you just can't legally buy it. So you can't give money to someone
Okay.
to buy marijuana. But
Okay.
that'll change.
Yeah. Yeah. Okay. Um, so what are the other impacts of this law to people? Are you allowed to walk around and vape marijuana? Like, what are the restrictions?
So yeah, there are several restrictions to it. So you're not allowed to consume marijuana publicly. You also, if you're going to grow it, you basically have to do it inside your home. So you're going to have some sort of, you know, indoor grow to grow the marijuana, because you cannot do that and you cannot have it out in your backyard. It can't be seen by a plane or in public view. So there's that restrictions. You can you can't smoke marijuana in public, but you still can have edibles in public. So I mean, if you chew on brownies or gummy bears or whatever, enjoy your edibles, you can still do that in public.
Well, that's certainly interesting. Um, and I know that this has come up a lot with clients. Children, edibles are adorable little gummies, right? And brownies and cookies. And it is, I have seen in my practice where children are getting into their parents' recreational marijuana and edibles, and it's causing some big problems. So in family law, we've got a couple things to talk about. You know, can people now, take advantage of using marijuana however they want to without any consequences to their family law case is one question. Because as you know, the law in family law says if you have a conviction of drug or alcohol within the last 12 months, there's a presumption against joint legal decision making. So there's a presumption that the non-convicted using parent be given sole legal decision making. Now, if you can't get convicted, that goes away.
Correct. That would go away. And what's happening right now is that prosecuting agencies were trying to get ahead of the law change by dismissing cases that were pending involving personal marijuana use. And I've seen a lot of cases um, with personal cases getting dismissed. I even seen some sales cases getting drastically reduced, like the charges being reduced and resolved uh, in some non trial ways. So um, yeah, that's already having an impact. And starting in July, if you do have a personal marijuana conviction, you can apply to the court to get those previous charges dismissed and expunged. And that's definitely a new thing in Arizona, because there is no expungement in Arizona. If you get a criminal conviction, the best you can do is to get it legally set aside. Expungement is different. Not only does it set aside the conviction, it completely erases it from the record. So whether you have an offense in the past year or the past several years, if it's a personal use case, you can actually get that thing sealed. And the burden is on the government essentially to prove that that offense was not a personal possession case or personal use. So it's
Wow.
good. There's all those procedures are coming. I anticipate that we're going to get a lot of clients that are going to want to expunge the record. We already get a lot of clients that want to set aside their record, whether it's domestic violence or a drug case or something. But I think that's going to be a big change, and it's a good thing. There's, like I said, the trend in the country is to try to not do criminal reform,
Mhm.
not just marijuana reform, like criminal reform. Like people want to decriminalize. Let me just rephrase this. There's a lot of criminal justice reform, and people want to decriminalize the consequences of punishment for drug offenses in general and other offenses, and encourage more of the rehabilitation aspect of criminal justice. So this is more in that trend, which is a good thing. And I suspect that Arizona courts are going to liberally interpret some of these statutes. I think that Arizona politically, Arizona's becoming more of a purple state, as they say, more blue than red. But Arizona's always had a really strong libertarian stance against government interference. And when the medical marijuana laws were passed in Arizona, the courts really liberally construed the new statutes, and they did everything they could to allow for medical marijuana to become the law in the state, and they really bucked some of the pushback that prosecuting agencies gave about medical marijuana. And the courts really liberally supported medical marijuana, and I assume that they're going to do the same with personal possession laws as well.
I think
So,
you are bringing up really fantastic points about understanding Arizona's culture. And it is this very libertarian culture. It's kind of anti-regulation. It's got an anti-government streak in it, which is not the same as Oregon, where I'm from, which is extremely liberal in the very in a traditional sense. Arizona is not like that. Arizona is more rebellious towards government. And in family law, it's the same way, where they don't want to know unless there's something massively wrong with one parent or another parent. They want out of it. Each parent gets to decide to parent those children how they want to. And in Oregon, where I've also practiced law, they don't do family law that way. So it makes sense that not only in family court, but also in criminal court, judges are like, look, unless there's a real issue that impacts the public safety, or in my version, it's children's safety, I don't want to know. People can do what they want. But they do have to deal with the statute. And the statute says if there's been a conviction, there's a presumption against you. So taking the action to get that expunged through an attorney like you is something I would highly recommend to anyone who may go through a divorce or family law situation who has a conviction for marijuana. Now, if there's a conviction that involves marijuana and other things, is everything expunged, or how does that work?
oh, that's a good question. I don't think we exactly know how that's going to work. The marijuana offense, generally, when someone gets charged with personal possession of marijuana, they also get charged with drug paraphernalia. Drug paraphernalia is anything that's used to ingest, use, or store illegal drugs. So typically, almost inevitably, if you get charged with marijuana, you also get charged with possession of drug paraphernalia. And drug paraphernalia will also be included with getting that expunged as well. So those are usually the two charges that get put together. Now, if you get somebody who gets charged with possession of marijuana, and maybe they had some sort of ancillary charge, like a traffic offense, or maybe they got charged with like maybe domestic violence. It's a scenario where a police officer goes to a home and it's on a domestic violence call, and then they see marijuana in plain view and decide to charge them for both. My take is that they will seal the drug charge, but then the domestic violence charge will probably still appear on their record. And that does raise a question too, is because police reports are supposed to be sealed under this new law if you get a drug conviction. So some of these reports, police reports, will include different types of offenses, and I assume that the whole police report would get sealed as well, because it'll be very difficult and time consuming for police agencies to, I don't know, redact or police reports or not. I assume they're just going to seal the whole thing as far as the police reports go. But I think that someone has like an ancillary charge, like like a domestic violence charge and a drug offense, that the attorney will probably move to seal the drug offense and probably ask the court to go ahead and set aside the accompanying charge that came with that offense.
Okay.
Um,
So could someone be charged with reckless endangerment of their children just because they had possession of marijuana?
my experience, I've never seen
Okay.
something like that. Um, I think I've seen. I think those arguments about endangerment come up in like dependency court.
Hmm.
Um, I seen that. I see that it's like neglect of the child. There's basically an allegation of neglect of the child because of the parent's drug use.
Hmm.
But that typically, and every once in a while, I do see it come up with when, like, it's usually like CPS responds to a call and there's a lot of drugs in the home, and maybe there's an accusation that they're selling, and then there's children in the home too.
Hmm.
I think I've seen that come up sometimes with that, with an endangerment charge. But definitely, it's definitely not typical. It's not typical for my clientele,
Hmm.
because I represent people that have the means to hire an attorney, and sometimes those types of crimes, those some of those crimes, are a lot of folks that can afford an attorney are get accused of different crimes that affect their demographics more than maybe somebody who's unfortunately might be at a, how do I say
Can you be
this?
specific? Because
Usually someone's selling drugs, they're not doing well financially, and they probably don't have the means to hire a private lawyer.
Mhm.
Uh, so I don't necessarily see those type of cases. I see a lot. I represent a lot of people who who are transporting drugs, are selling drugs, for sales, possessing drugs for sale, and then sometimes I get a lot of cases where people get tickets for possession of marijuana.
Mhm.
A lot of my cases come up through the traffic stop scenarios, but selling out of someone's home, definitely. I mean, it does come up. I mean, when someone's selling meth and stuff like that, I see some officers throw in like an endangerment charge before.
Okay. So this is pretty interesting stuff. Now, with alcohol, alcohol is legal, but if you are pass out drunk and not taking care of your children, that's of course going to affect your family law case. Now, with marijuana, um, does that happen? Do people get pass out, can't take care of their kids stoned?
Yeah, so that's interesting. So you're right. So when you try to figure out how marijuana is going to impact like the family law cases, and I've done some family law in the past, so I kind of know, I have some experience with how family law cases and criminal law cases kind of intertwine with each other, and I definitely don't want to step on your toes, Billy, about about it. But I think what people need to think about is that alcohol is a substance, and a lot of people are prone to substance abuse of alcohol, and alcohol is legal.
Hmm.
And so family law courts they already have to deal with substance abuse involving legal drugs,
Hmm.
alcohol.
Right.
So illegal drugs, and also like prescription drugs. And an individual can also can abuse prescription drugs. So in the family law context, people already litigate substance abuse involving legal drugs. So when marijuana becomes legal, that's not going to change.
Mhm.
I think what's going to happen is that there's still going to be a stigma with marijuana use, and those attitudes are going to change over time. And you know, I said and I don't want to get too far off my point, but we talked about how judges or the courts in Arizona are libertarian. Um, I'm talking about the appeals court. I mean, you're going to have trial judge. Each trial judge is going to be different. So it's important to have a lawyer who knows your judge. But
Mhm,
there are going to be some judges that are going to be conservative and going to be very resistant
mhm,
to legalize marijuana. And they're still going to have some attitudes, perceptions about marijuana and about how people use it and how they perceive how people abuse it. Um, so, marijuana is a drug. People can abuse it. You know, I'm not a drug counselor, but I think a lot of people associate marijuana with low inhibition. So you might have somebody, I'm not trying to stereotype, but you have somebody who's using marijuana excessively. Maybe they constantly possess more than an ounce in their home. Maybe they grow more than 6 plants. Um, Maybe it lowers their drive to be supportive for their family and their children as far as being a good earner, being attentive to children's needs and providing for them because they're stoned all the time. I mean, they're passed out on the couch eating chips.
mhm.
So those are the type of things that I imagine would come up in a family law court case is they would try to present a fact pattern to the judge that they're abusing marijuana and they probably maybe point out like their spotty employment record, you know, um, how much they do imbibe with marijuana and their use. Do they smoke in front of children? How responsible is their use?
Mhm.
Are they smoking in public? That's illegal.
Right.
You know, people smoke in public, and I'm sure that Arizona is gonna smell more stinky these days, but that's illegal. You're not allowed to do that. So I think that a family law attorney is going to have to point out. I think they're still going to make the abuse that someone's substance abusing
Yeah.
and how it impacts the family law relationship. So some judges are going to be more it's going to be more persuasive to some judges, some family law judges. Some judges are like, hey, let's move on, it's 2021, it's legal now. What's your deal? Why are you having a hard time with it? Why are you giving us such a hard time?
Mhm.
So I think it's going to be important because that's how judges, when it came to medical marijuana, that some judges gave different rulings about medical marijuana use and how that might impact the case. And um, I could see that happening in family law. It's going to take some time before these attitudes about legal marijuana changes, and some people might not ever come around to embracing it, so
Mhm.
to speak.
It is insane how much public opinion has changed. Um, I was just recalling, when I was in law school, I worked for the Department of Justice and we were doing termination of parental rights. And there was a case I worked on where these parents had their rights terminated. And one of the issues was marijuana. And they testified that they thought marijuana made them better parents. And it was so laughable at that time. It was such a ridiculous thing for them to say. Like everyone around them thought that was just absurd. And you could hear that now and have people not think it was absurd. It's just insane how much things have changed with regards to marijuana use and our attitudes in the last 10 years. And I think you're right. It depends on the judge. We have to know the judge we're going in front of. Um, and the facts matter. How you're using matters. Now, one thing that hasn't changed is you cannot drive high, right?
Correct.
So,
That's never changed. And even the laws pertaining to DUI and marijuana, even those things have changed over the years. And that started back with medical marijuana. So um, ba- the new law definitely it codifies that you can be convicted of a DUI if there is an active metabolite in your system and the government proves that it impaired your ability to drive to the slightest degree.
mm,
And that's the current law.
mhm,
Essentially, that's the current law, but now it's codified. So it's in the statute. And that's evolved. So back in the day, if you had smoked marijuana and it was in your system, and it didn't even need to be an active metabolite in your system, because
What is
there's
active metabolite?
so when you consume marijuana, the drug that's in your system that causes you to be high is carboxy THC.
Okay.
And what happens is a drug has a half life, and it metabolizes in your body into elements that are not causing you impairment, that are just the byproducts of having consumed it. And those things can stay in your system for a long time, for like 30 days. And when someone goes and gets a drug test, not only are they getting tested for the active metabolite, but the drug test can turn up the byproducts of smoking drugs, and those things still stay in your system. So back in the day, you could get pulled over for DUI and you smoked a month ago, and then there's some things in your urine and in your system that show that you did smoke, and it has no impact on your driving, but you could still get convicted for
Whoa.
that. And when medical marijuana came into play, that kind of the courts changed their they changed their the view on that, and they essentially said that that's not good enough to have a metabolite in your system. The government has to show that it was an active metabolite, that it was scientifically it could cause impairment, and the new statute codifies that. What's what's also interesting with DUIs and marijuana is that there is no legal limit, at least in Arizona, for committing a DUI with marijuana. So the government has to prove that there was an active metabolite in your system that could cause impairment, and then they have to prove that you were impaired to drive, because there is no legal limit. I suppose that that's going to change someday, that that the system will come up with some sort of arbitrary number
Mhm.
about levels of marijuana in your system to say that you're per se guilty of a DUI if you have that level. They're starting to come up with these levels in Canada
Hmm.
right now, and then there's some states, there's some legislation they're trying to push it, push some legal limits. We don't have that yet in Arizona. It's going to take some time. I think that right now there's not a lot of studies about marijuana because it's still a class 1 drug. It's still federally illegal. There's not a whole lot of valid medical research about marijuana. I think with the continued legalization, um, there will be more studies about marijuana, and I think they will come up with a legal limit. Defense attorneys are going to always argue that that legal limit is fraught with issues and is going to be arbitrary, like they argue that the current legal limits are.
Hmm.
But
For alcohol or for marijuana specifically?
well, there's definitely debate about marijuana, what levels can cause impairment. And I'm just saying that as a defense attorney, we're going to argue whether it's marijuana or alcohol, that those arbitrary limits are just arbitrary. They don't it Marijuana and alcohol affects people in different ways
Hmm.
physiologically. So it's when that's what DUI attorneys do when they go into court and they argue about DUI. They argue that there was no impairment, and that's not going to change
Okay.
as far as the DUI defense practice.
So,
But I know that DUIs, and you by the way, also add on, you cannot smoke marijuana while you're driving. That's illegal. That's codified. And then an officer pulls you over and smells marijuana.
mhm,
That is reasonable suspicion to do a DUI investigation.
mhm.
So, like again, no smoking in your car. If the officer smells it, even if they smell it on you, like your clothes or whatever, I presume that they will still do a DUI investigation just because of that smell, if that occurs.
So, let's get legalistic here for a minute. There's this thing called strict liability offenses. And strict liability means, like, if you run the stoplight, you're guilty of, you're guilty, period. Doesn't matter your intent, like, you did it. It's strict liability, right? And I think that DUI is the same way. If your blood alcohol comes in at over 0.08, you're strictly liable for a DUI, right? It doesn't matter if you personally were impaired.
Right.
But
That's the legal limit.
if there's no legal limit with marijuana, then do the cops need to prove, or does the government need to prove that this individual was impaired?
Exactly. So the government does have to prove the impairment because there is no per se strict liability limit on marijuana use. Now, because the labs can test for the level of THC in someone's body.
Mhm.
So we have the technical capability to test for those levels, but there's just no scientific consensus on what causes impairment for a person.
Okay.
And so right now the government basically has to prove two things: that there was an active metabolite in your system, active THC, and they have to prove that you were impaired. So an officer would the government, the officer would present testimony, for example, that to show impairment, they would show two things. They would either show that you're driving badly, or they would say that you did some field sobriety tests and that you performed badly. And then they would argue that that is evidence of impairment in
All
a
right.
DUI.
So that was the next thing I wanted to ask you about. Are the sobriety tests the same for marijuana and alcohol?
Yes and no. So some of the tests are the same, and then there's some additional tests that an officer who has more advanced training, who's a drug recognition expert, could do some roadside tests to show that you're impaired by the drugs. So a lot of the traditional field sobriety tests will show impairment, and that's what happens now. So somebody will get pulled over, maybe they were driving too slow or whatever bet swerving or whatever. They'll pull them over. The officer would do the field sobriety test. They would fail the walk and turn. They won't stay on the white line. They do walk and turn, one leg stand, an HGN, horizontal gaze, and nystagmus with the eye test. So someone could fail those. Then the officer will take them in. Usually they'll do a breath test, on the intoxilizer. They will blow up a zeros, 0.000. And so they have no alcohol in their system. At that point, the officer will ask them to submit to a blood test, and they'll take their blood. They could do a urine test, but nobody does urine tests. It's all blood tests.
Okay.
And the blood is what will either confirm or rule out the presence of illegal drugs or legal drugs, marijuana in their system. So, because they test for legal drugs and illegal drugs when they do a blood test. Okay. So that won't change. That's how DUI investigations are done now, because it's you can also commit a DUI obviously by consuming drugs, legal or not.
Mm-hmm. Okay. If someone finds themselves in that situation, should they do they have any option to not submit to a blood test?
Yes. So if an officer asks you to consent to a blood test, you can refuse to consent to a blood test. But if you do that, there are some immediate consequences, because civilly, you could lose your license for 12 months if you refuse to submit. And officers can also get a search warrant for your blood. So if you do refuse, 9 times out of 10, the officer is just going to go ahead and get a search warrant, and that's going to get granted, and they're going to get your blood anyway.
Mm.
So in a marijuana DUI case, I think that's the scenario, is that someone will probably not have alcohol in their system. They would have failed field sobriety tests that gave the officer probable cause to arrest them. They will submit to an intoxilizer test that might show no alcohol, and then they'll still get that blood test, because the officer can have somebody submit to multiple tests to gather evidence for a DUI.
Wow. To me, what's clear is there's still a lot we don't know. And there's a lot, like in terms of marijuana, how it affects, you. How long should you wait after you smoke before you drive? Like we know, we've been told, you can have one drink an hour. And obviously that's different for people, but that's the general knowledge, general advice that you're given. If you have more than one drink an hour, you shouldn't drive. We don't have that type of information to give people when they partake in legal marijuana use.
Well, I believe that in my experience, I have not seen a significant decline in alcohol DUI cases. And I think that marijuana DUI cases they're trickling up,
Mm.
but I suspect that there's just going to be more and more marijuana DUI cases, the more as more and more people start to partake of it. So I think it's going to increase, whether the government imposes a legal limit, a strict liability limit for marijuana in your system and driving. That could take years before that happens, and probably will happen at some point. But yeah, it's just going to go up, and it's going to be arbitrary at times. In my opinion, it's going to be arbitrary whether an officer thinks somebody's impaired by marijuana. They could have smoked 6-10 hours ago, still have that odor on their person. Officer pulls them over for something innocuous. All of a sudden it becomes this full-blown DUI investigation. It just goes downhill from there. And yeah, we're definitely going to see more marijuana DUIs, without a doubt. And as you know, a DUI can definitely impact a family law case, because if you have a DUI within, I believe, 12 months or so, there's some legal presumptions with that the parent is not entitled to make some legal decision making about the child in custody. So yeah, this is going to go up. Marijuana DUIs are going to go up, without a doubt.
Yeah. So my big takeaways from this are, if you've got a conviction in the past for possession or use of marijuana, go see an attorney about an expungement. That's the good news, right?
Right, for
How
sure.
how hard are those to get?
The expungements, I don't think it would be hard at all. It's pretty clear cut. What the law says. The Arizona Supreme Court is giving guidelines to the lower courts on how to administratively proceed with it. And currently, my experience with set asides, getting your criminal conviction set aside is not that hard already. So I think with the new expungement laws, it's going to be pretty straightforward. I think what someone has to do, consulting with the attorney, is going to be good, because the ad attorney is going to do a little bit of investigation to see if you qualify. They will draft the petition for you, maybe the proposed order for the judge to sign off on for it. There are some facts that need to be kind of investigated. Was it a personal case? Was it less than 2.5 ounces? Did the police report even say what the amount was when you got arrested? I was thinking about this and preparing for the show, is that when a lot of people get busted for marijuana, they might have several joints or a joint on them, but officers don't weigh every single marijuana case. So I think that there's going to be some people that are going to qualify. They might be in the gray area and still get an expungement. I think it's going to be pretty liberally construed
Mm-hmm.
and administered.
I know you're in Northern Arizona, do you have the ability to help people all over the state, or really only locally in Northern Arizona?
We do help people throughout the state. And then for the folks that maybe are in courts that we're not familiar with, we will refer them out to colleagues that can help them with. So
Wonderful.
definitely know attorneys all over the state, that's for sure.
Okay. So how can people get a hold of you if they're ready to move forward with this expungement?
We definitely will welcome their calls. They can reach us, they can visit our website, which is hamplaw.com. And then I'm on all the social media handles as at Hamplaw. But just call our office. It's 928-753-6868. And we'll definitely have someone that will talk to them and can evaluate their case and can quickly tell them if it's something that we can help them with or not.
Awesome. Thank you so much for your time today. It's been super informative and very interesting to me, and I really appreciate it.
Billy, it was great talking with you. Enjoy your podcast. And I don't know, at times it just felt like I was nerding out on some of this stuff, but it was fun.
We nerded out together. Have a great day, Shawn.
Right. Thank you.
Bye.